Welcome to the DisabiliTEA, a podcast where we have candid discussions about all things related to disability. Short-term, long-term, financial claims, impact on other areas of life, causes in the workplace, and more. With your host, attorney Anjel Burgess. You can find this show at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now here's the host of the DisabiliTEA, Anjel Burgess.
Good afternoon and welcome to the DisabiliTEA. Today we are pleased to have a very special guest with us, Attorney Wilson from the Atlanta Estate Attorneys Group. Welcome.
Thank you. Thank you so much for having me. It is truly a pleasure and an honor.
Absolutely. Well, we're excited to talk with you today and learn some more about estate planning, probate, and have you answer some very important questions for our audience. So let's just dive right in.
Yes.
First, if you will just introduce yourself to the audience and just explain what you do.
My name is attorney Tamarra Stuppard-Wilson, but you can just call me Tamarra Wilson. And I am an estate planning, probate, and tax attorney. I specialize in the area of basic to sophisticated estate planning, where we can manage small estates or large estates, as well as probate administration and guardianship conservatorship matters. I also like to take on some tax matters as it relates to the estate if there are outstanding tax issues as well.
All right. So first question that I have for you is, what is an estate?
What is an estate? I hear this question all the time, or sometimes I get a lot of people that say, I don't even have an estate, so why does it even make sense to do anything, right? An estate is comprised of anything that you own whatsoever. It can be as small as a bank account. It can be as large as real property, land, businesses. If your name is on a title, if your name is on a bank account or some type of deed, you have an estate essentially. Okay. Here in the state of Georgia, you're not required to probate that estate unless there are assets greater than $10,000. But typically it's easy to get to that number if you start adding up things like furniture, clothing, assets in the house. So typically everyone has an estate. They just have to realize what the worth of that estate.
Okay. So I know a lot of people, when they hear the word estate, they think wealthy. They think it's something only for wealthy people. But with what you just told us, you don't have to be wealthy to have an estate.
Not at all. And just to add to that, sometimes you need an estate in order to pursue things. So for example, let's say you passed away and you only had a minor child, or let's say you passed away as a result of a car accident. In order to pursue that lawsuit, an estate needs to be established. And in order to secure the asset for those minor children or those damages, you also need an estate as well.
So pretty much everybody has an estate or needs an estate, right?
I would say yes. But there's arguments to be made where sometimes an estate is not necessary. And in those situations where we can all agree, there is something called no administration necessary. So we could go that route and already have a judge issue an order. So I would always say start there. Start with what are the assets, and then now how do we get to them and protect them?
Okay. So I think a lot of maybe soon to be, if they're not already common situations where somebody might need an estate planning attorney or an estate attorney or a probate attorney, whatever role you want to assume,
yes.
Is, I would imagine, a situation where, let's say, there's an adult parent that may own the home, and the children can also be adults, right? But that adult parent passes away. Maybe the children aren't homeowners, But if that adult parent passes away, then what happens to the house?
Exactly. So what happens to the house is it all depends on whether that person had a last will and testament or a trust or not. Okay. But let's
Okay.
say that parent passed away without a will. Then there are laws in the state that says, hey, without a will, this is what happens and this is who receives that property. Again, what does that mean? You need an estate. There always has to be someone appointed who has the legal authority to make decisions and transfer assets. That's typically called the executor or executrix, or if you don't have a will, then it's usually the administrator or the personal representative. So if you don't have someone in that role, it's almost impossible to legally transfer property. So essentially, you almost always need an estate. And if that parent died and they were unmarried, then typically the monies would go or the assets would go to the children equally. But again, one of those children or someone needs to serve as the administrator to pass on that property.
Okay. So in situations where, let's say there's that same, at least starting situation where there's the parent that owns the home,
Mhm.
but what if one of the children is living in the home as well?
Mm.
And that parent passes away, but there are multiple children. So not only is there the child, or the adult child that's been living in the house, but there are other adult children um, who may or may not like the situation.
Mhm.
Um, if there, can you give us an idea of the different scenarios that you think
Absolutely.
that?
Now, that scenario happens all the time, and I'm gonna be honest with you, that's where I probably, I would say end up in court about 80% of the time,
Wow.
because typically, the reality is as our parents or our loved ones get older, they usually have someone that they start relying upon around that time frame, okay? Especially as we're talking about diminishing capacity, and as you know, as a Social Security attorney, you probably see this all the time. They're trying to get help with disability because they have dementia or some cognitive issue. Well, in a situation like that, that doesn't make outside children or children that aren't living in the home less entitled to those assets, right? And I hear this all the time. Well, my brother didn't help, and my sister doesn't even
Mhm.
come to visit mom. That really
Right.
has nothing to do to what they're entitled to per the law. Per the law, it says that those children are equally entitled. So, with the scenario you provided with one of the children living there, they probably were the ones closest to mom or closest to dad. They probably have access to bank accounts, right? They probably been paying bills or doing different things in assistance, right? Not necessarily, it's not always malicious sometimes. Usually they're taking great care of mom. They're doing a great job. But at the end of the day, they might feel a little bit more entitled. They're like, I've been here. I've been working hard. I've helped with some of the bills, maybe, you know? And so what happens typically in a good situation, what happens is everything still goes equally to the children. But that child that was living there, if there's outstanding debt, meaning things that they paid for on behalf of that parent, sometimes they can be reimbursed because they're considered a creditor to the estate. So we
Okay.
usually start there. We'll say, hey, give us all of the expenses. Maybe you had to pay for a wheelchair. Maybe ended up paying for the funeral services. Give us a list of all of those debts, because those things are considered priority debts and they're removed from the top, the bottom line. Okay. Then, you have your taxes, which is also a priority debt, your governmental loans, if you will. So if there's any student loans, those are considered priority, and legal fees are considered priority debts. Okay. And we'll talk more about how you can afford this type of service using this, information. But with that being said, you take care of all the debt, and then whatever's remaining would then be split equally between all the children. Well, I hate to say it, a lot of times that child doesn't feel that way. That child says, you know what, I'm here. This is my home. I've been caring for mom or dad, and I'm going to stay. Well, unfortunately, that's when we have to take other provisions like eviction. We end up in litigation. We end up in court. I mean, at the end of the day, the law says what it says. Everyone's entitled. So that doesn't change because you feel like you have more of a right. Essentially, what's going to happen is they're going to end up being put out. And the legal fees as a result of all of that work is probably going to, their portion of the asset is going to be offset by those legal fees. That's going to be what happens. Yeah.
So how do you avoid that situation? If I'm the parent, how do I avoid that situation with my adult children and the one that's been taking care of me when I'm gone?
Yeah. So I tell people the first part of it is just to sit down and have a conversation with your kids. And I hate to say it, there's always going to be one person that does not necessarily agree. Okay. But if you could get everyone at the table and have a conversation and share, this is what I want, have them be inclusive as a part of this process so that everyone understands what you want. They have clarity, whether they agree or disagree. We all heard the same thing, right? I would say that's the first step. The second step is you need to have some essential documents, and that includes either a last will and testament or a trust, a healthcare power of attorney, an advanced healthcare directive, and I would say a living will, but here in Georgia, it incorporates the living will provisions, and a HIPAA authorization if you could get one drafted as well. Those documents I would say is essential to saying this is what I want during life. Right? If I'm incapacitated and I need help with decision making, these are the people I want to make those decisions. This is how I want those decisions made. And then when I ultimately pass away, these are my assets and this is how I want them to be transitioned to the next person.
Okay. So with those within the will or trust, whichever is used, the parent can say, I want, Tommy, who's been living with me and taking care of me, Tommy gets the house.
Exactly. And that happens all the time. They'll say, hey, everyone knows that Tommy's been here the whole time. Tommy's going to have the house. And if they sell the house, right? Or if Tommy sells the house, we can maybe give a portion of that to the other children, or I have these other assets I'm going to split up between all the children, but Tommy's going to get the house because he's been here, he's been maintaining it for me and has done some work on it. I think he deserves that benefit, and that's okay.
Okay. All right.
Now, I will add this. There's a difference between the will and the trust, where the will you still have to probate. Okay. So even though you have a will, I think I get a lot of clients that come to me, they say, hey, I've been listed as the executor of the will. Can I start transferring money? No, you cannot. You have to file a petition to probate that will. And then once the court appoints you as the executor or executrix and issues an order saying what your powers are, that's when you can go ahead and start making decisions about the estate. Whereas the living trust, you do not have to go through the probate process. You can make decisions as the trustee immediately when someone becomes incapacitated or upon death. So that's the biggest difference there.
Well, that's an important distinction.
It really is. It really is. And I say, sometimes it's difficult for people to work in the realms of trying to get a trust set up because it is more costly. I do understand that. But honestly, you're going to invest the money up front when you're doing a trust and alleviate some of the heartache of notice and filing petitions and fees from the probate court. Ultimately, you might end up spending the same thing anyway, right? Versus now, maybe it's smart to come together as a family, and support mom in getting that trust so that you all can work cohesively when she's no longer with you all.
Okay. That makes sense. So with the will, and I understand that it has to be probated, but what if the person that is, designated in the will to be the executor, what if, let's say, another child says, well, I don't think this person should be the executor because for whatever reason. Is that an issue that too can be addressed in probate court when the will is probated?
It actually can be addressed, but the problem is just because I don't like something is not good enough reason to try to have someone removed or not allowed to serve. At the end of the day, the goal of the probate court is to essentially make sure that that decedent's last will and wishes are brought into fruition, right? So you'd have to have some type of justifiable reason. And the statute is very clear on that. There are good reasons for that, right? There's fraud. There's malicious behavior, right? Are they trying to steal? Maybe there were things done prior to mom's death or leading up to mom or dad's death that gives you good reason to say, you know what, this person is not going to be a good fit, or they're not going to make the right decisions. Another thing that looks at is this person able to work with everyone? You know, if you're the person that nobody likes and nobody talks to and has not kept in touch with family members, you might not be the best person to serve, because no one's going to respond to you. You don't know how to get in contact with anybody. You're probably still have some underlying issue with certain individuals, and you don't want to do the right thing for that reason, right? So those are things to consider. But I will say, what your question basically is alluding to something called an objection. So when a will is filed with the court, or a petition to probate the will is filed with the court, then at that point you have 30 days. All of the heirs have 30 days to respond, to say, hey, I agree with it or I don't agree with it, for whatever reason, right? And that's called an objection. And if an objection is filed, more than likely you're going to either end up in mediation or a hearing. It just depends on the court and how they like to move forward with those type of cases. But I will say, just off the bat, it's going to be more costly as a result of that, because now we're talking about discovery and litigation and mediation, which is very costly, and time, right? Because now it's going to take time to get together, get on a calendar, bring out all the issues, and then allow the judge time to make a decision. So it can be expensive as a result. But if there's no valid reason for doing that, most of the time I would recommend getting an attorney to hopefully file a motion to dismiss it. Or if you do end up in court for something very frivolous, then maybe make that argument to ask for legal fees from the person who objected in the first place.
Okay. So it sounds like it all circles back to, this is why it's important as the parent to sit your children down and have a discussion about, this is what I want.
Yep.
This is how this is what I expect. This is how I expect things to go.
Exactly. And I'll say, our parents' generation, they're very conservative, and they did not frequently have these kind of conversations. The reality is, they wanted to protect their wealth, and there's a lot of nervousness there. They worked very hard, and this is probably the first, you have your first to go to graduate from college, your first to do a lot of amazing things, and they just don't want to risk losing those assets. But a part of the reason why we as a community lose assets most of the time is because we don't have these conversations and we don't plan. So it's always better to plan. And even when those conversations are had, I understand that does not mean that you have a legitimate will from a conversation. But I will tell you, all the times when the conversations was had, there's enough witnesses, right? Enough people to sign an affidavit and say, hey, I know this conversation was had. I know this is what mom or dad would have wanted. And that can serve as evidence when we're in there in front of a judge to show what that person desired.
Okay. So on the front end, as parent, you either get a will or a trust to try to prevent any, let's say, chaos from occurring when you're no longer here. Right. But in situations where it's too late and, families find themselves, mom or dad has passed, there are siblings, there's a house, there could be multiple assets, and they don't know what to do. How do they proceed from that point?
I always would recommend getting an attorney. And I do understand that there's a financial obstacle sometimes, but I always would recommend getting an attorney. And there's different attorneys that serve different clients. And there are enough attorneys out there that can help you make it more affordable so that it gets done. For example, I will allow the estate to pay most of my attorney's fees. So there will be a deposit or a retainer that's required for me to get started, because just up front, you're going to have to file several petitions just to get started. Okay. And that's a lot of work to do. But I will work with the family and say, hey, once someone is appointed as the administrator and they have access to funds, at that time, I'll collect the rest of my attorney's fees. So there are ways to get it done. We also do payment plans. And sometimes, there are, at least one of the heirs may have a credit card. Put it on your credit card. Then essentially you become a creditor to the estate, right? You're entitled to get some of those monies back. And so then once we have access to more funds, at that time, you can also reimburse yourself and get the money back as well.
Okay. So if there's a situation then where, there's a house and maybe the adult children feel like they are not financially in a position to hire an attorney, this certainly seems like it shifts most of the financial responsibility, at least beyond the retainer, from the children to the estate. So if there's a house that needs to be sold, would it come out of the proceeds of selling the house?
Exactly. And I always tell families this, like, they have this idea that, hey, am I now responsible for mom's debt? Am I now responsible? Absolutely not. You're not. You're just whoever the fiduciary or the administrator is going to be. That person is responsible for taking care of the things of the estate, but you're not responsible legally to pay obligations, etc. Now, what I will say, though, is as a fiduciary, if there are assets that can take care of debt, they do need to be paid before you pay yourself. So you can't transfer the money out and say, oh, there's no money left. No, those are priorities. So you do have to take care of the expenses and things like that before, but now you have access to the money in order to do that. But not having the money for an attorney will not prevent you in many cases if the estate has assets. And that's usually one of the questions, when we're talking about how much the fees are in the first place, we have to get an idea of how much work we have to do, right? So if there's real property, does it need to be sold? Are we going to have to draft any deeds to transfer that property? Bank accounts, do we need to get access to that? Sometimes with investment investment brokerage accounts, you have something called a medallion, which could be really tedious to get, but we can guide you in that process and make sure that you get those things. Vehicles, transfer them from one person to another and working with the DMV in order to do that. So it just depends on the situation. Those are probably some of the more simpler examples, but then you have farmland and gas. I mean, it can get really complicated depending on what type of assets are in the estate. And I think most of the time, if we can kind of assess what that looks like, then we can determine, hey, maybe a portion could be paid now and a portion could be paid later once we're able to address those things. But at least we could get things moving along, right?
Okay. So the key is, regardless of your perceived, I can't afford an attorney, talk to an attorney, reach out to an attorney, and let the attorney do the consult and figure out what things are really going to cost before you make the assumption that you're not able to afford it.
Exactly.
Because otherwise, what happens if you do nothing? Then what happens?
Well, I would say the worst scenario is things go into foreclosure, properties. I've seen this a lot. Or I get calls the umpteenth hour. My house is foreclosing tomorrow, but it's a probate property. What do I need to do? I can't help you now. It's tomorrow, right? But if you were more proactive, we could get the petition filed. We could notify the mortgage company, and they may or may not work with us. Hey, but you never know what could be done if you have more time. And most people are understanding and are very responsive, and they get it. People pass away all the time. So this is not new to these type of entities. It's just more so the communication. They don't hear from you. They don't know what's going on. They don't know anyone has passed away. That information is not just sent automatically to them in any kind of form. So It's more so communicating, trying to let people know that you're trying to handle the matters of the estate, that our money's there. We want to give it to you. We just need the time to get it done.
Okay. All right. Well, that's really helpful because that's one of the things that I hear people say all the time. I can't afford an attorney, and because it's outside of my area, and things kind of work different with Social Security. I just kind of say, well, maybe it's just that expensive. I don't know.
Yeah.
But to hear that there are lots of creative ways.
Yes.
To make sure that the attorney's fees are paid and that, you as the client get the things that you need. That's great information. So thank you for sharing that with us.
You're welcome. You're welcome so much.
So before we wrap up, are there any tips, tools, just anything that you want our listeners and viewers to know about estate planning, probate, any of those things that you would like to share?
Okay, I absolutely do. I do want to just remind everyone that there are some essential documents, right? And that would be your last will and testament or your trust. And if you're considering a trust, it's a great idea. It's not for everyone, but a consultation won't hurt. Typically, I usually charge $200 to do a consultation. If it's anyone on a show, like a referral from you, Attorney Angel, we usually charge just $50. Okay. So $50 you've invested and you get a wealth of information for over an hour. Talk about anything that you need to talk about as it relates to your estate. And most of the time, the recommendation that I provide is more than enough for you to either move forward or have the tools to hire an attorney. Okay. But I would say the things that you need to have is your last will and testament for sure, or a trust, because that's going to tell us what you want to happen when you pass away. And that right there alone stops a lot of people from litigation, fighting, all of that. There's also a really nice thing we can put in both of those vehicles, which is called a non-contest clause. And what that says is, hey, if you contest, if you fight or start trouble or create litigation, you get nothing. And a lot of times people have to stop and consider that. Hey, there's a possibility I could lose everything if I try to do this. So let me make sure there's some legitimacy to what I'm claiming before I move forward. Okay. The other thing is power of attorney and healthcare directive. Anything could happen to any of us. I wouldn't say that this is just for older people. I would say this is for all people. If you are age 18 or above, you want to have that document. And I'll give you an example. I've been having a lot of emergency hearings that's been around young children, 18, 19. They go off to college, right? We're getting ready for that season right now. They go off to college and something happens, whether it's a mental illness episode, whether it's a car accident, something happens. And guess what? They're considered an adult. And they do not have, no one has to legally talk to you as a parent because they are considered an adult at that point. And that creates a lot of issues by the time you're able to get an emergency guardianship or emergency conservatorship. So much has happened, right? They've probably been given all kind of medication. Who knows, right? And so you've had no say in your child's care, and you've had no ability to help them. I don't know, maybe pay a car note that was behind or pay rent that was behind. So you want to make sure that you have those documents in place, and it's fairly inexpensive to get those two documents for sure. And the last thing I would say is, things like your bank accounts, right? And your life insurance. You have the ability to identify beneficiaries, and that doesn't involve a will. That's just a form you fill out and you say, hey, paid on death, when something happens, this is who I want to receive those monies. And they can take care of funeral expenses and things of that nature right away, right? Or life insurance for minor children, if your concerns are, hey, that living parent's probably not going to do the right thing, or I don't think, I don't know who's going to take care of my child. You can leave life insurance to maybe a trust and make sure it's paid out in the way that will ultimately benefit those minor children. So you do have flexibility there. Let's make sure those forms are filled out. Let's make sure we're identifying people that are going to do the right thing by you and your loved ones.
Right.
And that's without a will. That's just being prudent and making sure those things get done.
Okay. Well, great tips, great information. Thank you so much for joining us
You're welcome.
and sharing such a wealth of knowledge. Last thing that I want to just point out is that people are going to want to talk to you.
Yes.
How can they reach you?
Okay, so my phone number, the office number is 470-3-TRUST. 470-3-TRUST. Okay, so that's 470-387-8787. My email is Tamarra W. ATL Estate Attorneys North, and I now have a North office right here in Marietta, which is located at 3750 Palladian Village Drive. You can visit my website at www.atlantaestateattorneys.com. But that mostly shows the Atlanta office. Now that's going to be updated to show reflect the Marietta office. But you can always reach out to me anytime, and I'll be sure to respond back to you as soon as possible.
Perfect. Well, thank you so much, Attorney Tamarra Wilson, for joining us. And this has been another great episode of the DisabiliTEA. We look forward to talking with you next time.
Thank you for having me.
Thank you.
You've been listening to the DisabiliTEA with Anjel Burgess. Thank you for your positive reviews, comments, and sharing the show with others. You can catch prior episodes at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.